How does a Cook Islands trust work? If you are concerned about lawsuits, a Cook Islands trust is probably going to be the best solution for you. So let's say you live here in the United States. You are the client. Let's not forget Texas. As much as Texas may want to be forgotten, it's still part of the United States. So you're the client and you're here in the USA. The first thing you're going to do is contact the tiny island country of the Cook Islands and set up a Cook Islands trust. Once your trust is established, the Cook Islands will then contact a bank over in Switzerland. The bank in Switzerland can invest in stocks, bonds, various different currencies, US dollar, Australian dollar, Swiss franc, British pound, the euro, and even crypto as well. So once the Cook Islands Trust is registered, the Swiss bank account is opened, you will then wire funds over into your Swiss bank account. The money is invested, you go about your life happily. Now, if you want some money out of the trust, you're not going to be able to take it directly out yourself. You have to first send a request over to the Cook Islands. The Cook Islands would then review the request, make sure you're not acting under any form of legal duress, and then they'll send a message over to your banker in Switzerland to release the funds, and then about a week later, you'll have money wired back into your account in the United States. Now, if a court ever orders you to make a request, you will of course comply. We always have our clients comply with court orders, and you will send that court-ordered request over to your trustee. So here we have the scales of justice. You've got a court-ordered request coming out of the United States. It's a request from the court. This type of request, the trustee will review, and they will see that you are acting under duress, and they will block that request. Typically, anytime you want your money out of a Cook Islands trust, you'll be able to get it out. However, if you're acting under legal duress, if you're only making a request because you've been ordered by a court to make a request, that will be blocked. This structure is what we use for 99% of our clients, where we register a trust in the Cook Islands, open up a bank account in Switzerland. Cook Islands is the best jurisdiction for registering asset protection trust, and Switzerland is the safest jurisdiction in the world to hold your money. The combination of the two will give you the utmost peace of mind that your money is safe and protected. Good afternoon, good morning, and good evening, depending on where you are in the world. I'm attorney Blake Harris, and today we will be discussing common myths in the asset protection industry. The first myth that we're going to be looking at, or the first group of myths, are the misconceptions that plague the asset protection industry. So the most common issue that we confront is people who think they don't have enough money for an offshore trust, or they've been told that you need tens of millions, or even billions of dollars in order to justify setting up an offshore trust. This is far from the truth. I'm going to illustrate with a quick example. Let's say we've got two clients. First client is worth $2 million. Second client is worth $200 million. If both of these clients get sued for $5 million, the client who has $200 million, my advice is going to be hire the best defense attorneys you can, fight this as hard as you can. And if you end up losing, $5 million is not going to have any significant effect on your standard of living. However, if an individual with $2 million gets sued, I'm going to say you need to fight this as hard as you can. You need to negotiate a better settlement, because if you risk this going to trial, that could be catastrophic. Interesting enough, the majority of people who set up an offshore asset protection trust, my law firm, have between about $1 and $10 million in assets. So you do need some level of wealth, but it's not a tool that is reserved just for the super rich. When you create an offshore asset protection trust, it's generally always set up as an irrevocable trust. But do not let the term irrevocable scare you. It does not mean that your money is locked away forever, despite the common myth. Irrevocable simply means that a court cannot order you to break or dissolve the trust, or order you to pull assets out of the trust. Irrevocable does not mean that it's inflexible. The trust can still have property added into it. The trust can still have property taken out of it. The trust can still be amended, and you can always direct how the money is invested. So although the trust is irrevocable, it doesn't mean that your money's locked away forever. You can still use it, invest it, or if you even desire, you can make a complete distribution of the trust assets and essentially dissolve the trust. Irrevocable in combination with offshore means protected, but in no ways does it mean that you lose access to your money. Why not just use a U.S. trust? Well, interesting enough, there's some case law which explains this. And basically what the case law says is that if a U.S. creditor fights hard enough, pushes hard enough, eventually they can get to assets within a domestic trust. While the promoters of domestic trust will often claim that the domestic trusts are as protected as offshore trust, or that the third-party trust fixes the problem of offshore trust, the reality is that is not true. Offshore trusts give much better protection. There's many more hoops you have to jump through, and it's much more expensive to break an offshore trust than a domestic trust. And it's part of the reason that it's so rare anyone even attempts to break an offshore trust. What most people will end up doing is simply taking a settlement as opposed to even trying to break an offshore trust. But you're playing two very different ball games when you're defending your assets and you have an offshore trust which a U.S. court cannot break, and compared to a domestic trust which a U.S. court can break. Another common misconception is that offshore trusts are illegal or they're just for hiding money. As far as hiding money is concerned, you have the right to go in your backyard, grab a shovel, dig a big hole, throw all of your cash in there, throw some gold in there, throw your crypto ledger, throw any asset you want, and you will have hidden the asset. However, if a court ever asks which assets you have, you're going to need to disclose everything you buried in your backyard. You're also going to need to disclose that you have an offshore trust. If you fail to disclose, that could land you in jail. However, the difference between the hole in your backyard and the offshore trust is with the hole in your backyard, a court could order you or could order someone else to go dig it up and they could seize that asset. When the assets are held in an offshore trust, you would disclose this to the court, but the disclosure of the asset in no ways compromises protection. Also, there's been a very good job done by the Hollywood media to convince the public that any offshore business is shady or illegal. There's nothing illegal about creating an offshore trust. You will not go to jail for creating an offshore trust. And we'll talk more about that a little bit later in today's presentation. Next, we have people who want to wait to set up an offshore trust. Well, I got some bad news for you. You can't buy fire insurance when your house is on fire, and you're not going to set up a sound asset protection plan after a lawsuit or a threat of a lawsuit has begun. Now, it can be a little bit unclear sometimes when a lawsuit is actually threatened or when it's too late to set up an asset protection plan. So if you're not sure whether it's a good time to set up an asset protection trust, contact my law firm. We can dive into your particular situation and let you know whether you're in the clear to set up an offshore trust. Do offshore trusts get set up sometimes after a lawsuit has begun? Yes. Does it give the same level of protection? Absolutely not. It may be able to help mitigate some damage, but if you want asset protection, you do it before any threat or any lawsuit actually begins. Next, what if my foreign trustee steals my assets? Well, to be totally honest, this is a little bit of a concern whether you're using a domestic trustee or a foreign trustee. And it's the reason that I am so adamant that individuals who are looking to do asset protection planning, whether it's international or domestic, they work with only the most reputable providers. A reputable provider will be licensed with the government they work in, and you're going to notice that they have incentives that keep them honest and keep them wanting to continue to protect your assets and maintain their reputation. Myself and my partner, Marcos Almeida, down in the South Pacific, have founded Atlas Trust Company. Marcos is the best trustee in the industry, the most reputable one as well. And him and the team at Atlas and the other trust companies in the Cook Islands are all very well paid and taken care of when they work in this industry. It's a very special industry to work in, and we provide some very good jobs and a lot of money to the countries that we work with. They want nothing more than to protect their reputation as a jurisdiction where your money is kept safe. In combination with that, you remain the beneficial owner. So according to the terms of the trust, only you could benefit from the assets. Plus, we usually structure the plan where the trust owns an LLC, then the client serves as manager of the LLC, giving the client full control of their assets. And also, the bank account, which holds the trust assets, is typically held in Switzerland, which is probably the safest banking jurisdiction that an American can open a bank in. But once I put my assets into an irrevocable offshore trust, I'm going to lose access to them. That is a myth. The reality is, if you want to invest your money, you can do it. Really, the only time that you would lose access to your money is if you are requesting a distribution from your trustee because a court has ordered you to request a distribution. Generally, anything you ask of the trustee, they will do for you. But if you are in a position where a court has ordered you to repatriate funds, you will comply with the court request. However, the trustee sitting offshore in the Cook Islands or another jurisdiction that does not recognize U.S. court orders will not release the funds. So you will still have access to your money at all time. The only time you'll lose access is when you don't want to have access to it. So the next myth is kind of a fact, but I want to dig into it a little bit deeper. Any attorney can set up an asset protection trust. In my opinion, setting up an asset protection trust is actually quite easy to do the wrong way. There's lots of little landmines, lots of little pitfalls where if you don't do it properly, it could cost you dearly. It could mean you don't get protected. It could even mean civil or criminal penalties could come your way, or even worse, you could end up having your money stolen by some rogue person in the industry. And unfortunately, while the asset protection industry is a legitimate industry, there are lots of pirate ships out there, and working with the wrong attorney can cost you dearly. You want to work with someone who specializes in this area. You want to make sure that attorney is actually working for a legitimate law firm owned and run by a licensed attorney. So be sure to do your due diligence, ask about the experience, get things verified in writing, look for third-party recommendations that go beyond just an individual making claims about themselves. So yes, while in theory any attorney could set up an asset protection trust for you, there's really only a handful of us that are highly specialized, skilled, and experienced in properly setting up for an asset protection trust. Asset protection costs too much to be worth it. Asset protection costs more than basic estate planning. Asset protection also costs a lot less than paying for a lawsuit or paying for a judgment. I'll put those three in perspective. If you're looking at a basic estate plan, just a trust to pass your assets to your children after you pass away, that may run you $3,000 to $5,000. If you're looking for a asset protection trust to protect your assets while you're alive from lawsuits and creditors, well, that's going to run you anywhere from $20,000 to $40,000, which is more than a domestic estate plan. However, it's probably a lot less than you're going to pay to defend a lawsuit even before it goes to trial. And then if you go to trial, it's going to be probably another $100,000, $200,000. And if you end up losing a trial, that could be hundreds of thousands of dollars or millions of dollars in judgment. The amount that you pay to protect yourself from that judgment and from needing to even defend the underlying litigation, because once you tell the opposing party that all of your assets are already protected, there's a good chance they'll drop the case or be willing to make a much more reasonable settlement offer. So in terms of the cost to set it up, it is a very small amount of the money that you would be saving in the long run. In general, if your net worth is over $2 million and you have some concerns about lawsuits, asset protection can be an extremely good value. Next, let's go to myths that can cost you money. So why not just find a discount provider? And you can find individuals, companies out there that will set up an asset protection trust for you well under the market rate of $20,000 to $40,000, with some companies charging as little as $10,000 to set up an asset protection trust. However, discount service providers can end up being very costly. First of all, chances are what they are cutting out is the law firm. Now, be careful with these discount service providers because some of them will appear to be law firms. They will claim to have attorneys on staff or legal experience or legal knowledge or even connection to attorneys, and some will even over the phone tell you that they are a law firm. But do your own research and verify that you are working with a legitimate, recognized, credible law firm. Because if you're not working with a real law firm, even if they tell you they have attorneys on staff, you are not getting the benefit of the attorney-client privilege, which can be vital in the event of litigation. It also means that your provider has no regulatory oversight. So if your trustee goes rogue, if the company you hire just takes your money and disappears, there's no way for you to have any recourse against them. Usually there's no bar association that you can report them to. Or if you get a trust company that's unreliable, which is more likely to happen if you're working with the discount service providers. Discount service providers generally will work with second-rate trust companies, second-rate banks, and you're going to find that the service you get is much worse. And you may end up regretting doing any asset protection planning if you end up doing it with the wrong person. Or you may decide you wanted to have the asset protection planning, but not with the initial provider. And they're not going to be interested or quick to give a refund because, after all, you've got no one to complain to. And then you end up having to pay for the discount service provider who probably didn't disclose all their fees up front. So you pay more than that $10,000. And then you have to go and hire a legitimate law firm to redo the planning and put in their own planning. And that discount provider ended up costing you dearly. Well, if you speak to someone and they sound like an expert and they look like an attorney, then you can trust them to protect your assets. Well, I'd be very careful out there because there's this gentleman, you see his face there on the right with the word fraud on top of it. His legal first name is Kevin Wessel. You may know him better as the business guy. He runs companies known as Asset Protection Planners and Lawyers Limited. Last year, I filed a federal lawsuit to get him out of the asset protection industry. I've also exposed his dishonest business practices on the offshorewatchdog.com. It would take me more than a few hours probably to go through everything that Wessel has done, which merit him being removed from the asset protection industry, but I'll just highlight a few real quick in about 60 seconds here. Number one, a court has previously ruled that he was the mastermind of a fraudulent asset protection scheme, where at court he gave the most invasive testimony they had experienced in their 33-year history, and there were times when the court said he lied at trial. As a matter of fact, I was just in court with him a week ago and listened to him, I believe, lie many times at trial. The IRS has described some of his activities as the hallmarks of tax evasion. To me, it's unclear whether he's even running a law firm right now. After I filed the federal lawsuit, he stopped talking or significantly reduced the numbers of times that he was mentioned that he was running a law firm. His own engagement agreement, I believe, says that you're not working with a law firm, which means that there's no attorney-client privilege involved. I've talked to past customers of his who have said they got straight up scammed. They paid and they never got the trust set up. And I even spoke to someone who said they paid about $1 million into a bank account, held it in cash. When came time to get the money out, they only got about $900,000 in industry for over 35 years. But his own YouTube channel, until I called him out for it, showed that about 12, 13 years ago, he was actually running or at least marketing a pawn shop. You can read all about Wessel at the offshorewatchdog.com. A DAPT or a hybrid DAPT is as strong as going offshore. So a DAPT is a domestic asset protection trust. A hybrid DAPT is a domestic asset protection trust, but you name somebody else other than yourself as the beneficiary. You can read about hybrid DAPTs at hybriddapt.com. Both are subject to several vulnerabilities, the main one being that the trustee is required to recognize and abide by a U.S. court order. So unlike a foreign trust where a U.S. court order is required to be disregarded, the trustee of a domestic asset protection trust or hybrid domestic asset protection trust does have to comply with U.S. court orders. And plaintiff attorneys know this, and they are much less willing to make a settlement offer, to accept a lower amount for settling a case when they know that if they press hard enough, they can get the assets. There's a lot of case law where third-party trusts, where and self-settled DApps have been broken. You're not giving yourself nearly the same level of protection that you get with an offshore trust, and you're not giving yourself nearly the same level of settlement leverage. And that's really the main thing. Most cases settle, and what we want to do is put our clients in the best possible position to settle a case. Don't get fooled into setting up a hybrid DApp or a DApp. If you want real protection, you go somewhere where a U.S. court cannot touch your assets. A bridge trust gives me offshore protection without going offshore. So the basic concept is a bridge trust is a domestic asset protection trust that in the event of litigation can be converted to an offshore trust. There's a successor trustee named in the trust. In theory, it sounds great. And many years ago, I was selling quite a number of bridge trust. I thought that I was giving my clients offshore protection. I thought that it would be easy to convert it when the time came. However, as I got farther into my practice, I traveled to the Cook Islands. I met with, at the time, I believe every trust company in the Cook Islands. I discussed a number of things, including the bridge trust, and I got the same message from all of them. There is no guarantee these trusts trigger. The trust companies will do another review at the time it comes to trigger the trust. And the trust companies have the right to deny stepping in to the position as trustee. And a bridge trust is simply a successor trustee trust. And it has happened before that a trust company will do another review and say, we don't want to take this case on. And the client ends up getting left holding the bag. It is risky planning. I highly recommend you don't gamble with your client's assets or don't gamble with your own assets and set up a bridge trust. These are often marketed as offshore trusts. They're not. That is a lie. They're domestic trusts, which could later become an offshore trust. But the reality is any domestic trust could later become an offshore trust. To read more about the bridge trust, go to thebrokenbridgetrust.com. Again, that's thebrokenbridgetrust.com, just like the offshore watchdog, thebrokenbridgetrust.com. You can read all about this type of planning. Cook Islands trusts fail all the time. Look at the 45 failed FAPs. Many years ago, a asset protection attorney, we'll call him, created a list of 45 failed foreign asset protection trusts. This was a big reason that a lot of people hesitated to get into this type of law. It's the reason many customers chose not to set up a foreign trust, and instead they went with a domestic trust, a vulnerable, risky domestic trust. I was very skeptical of what the author put out, and I knew that some of this information was not accurate. So I had my team dive deep, and we researched every case as far as we could from the initial decision all the way to the final appeal. And what we found on the list will shock you. You can read the full finding at 45fact.com, but I'm just going to read some of the key takeaways. None of the 45 cases show a properly formed, timely funded offshore trust with an independent trustee being defeated on the merits. The cases show courts punishing fraud, concealment, retained control, and post-claims transfers. There were several entries which involved no trust at all. Offshore bank accounts, annuities, credit cards, corporations, one constructive trust disputes are counted as trust failures. The number itself is inflated. 2 entries duplicate other cases on the same list, and 2 could not be located despite extensive research. A contempt order against a debtor is not a piercing of the trust. In case after case, the settler was sanctioned personally while the trust corpus stayed offshore and untouched. Court order entered is not assets recovered. In several cited matters, the creditor never reached the trust funds, the case settled, or the court expressly declined to act against the trust. The author of this list, when I pointed out on LinkedIn a few days ago that there were some inaccuracies, actually responded, and this is a licensed attorney, a well-recognized, distinguished attorney, responded by saying that he had not read all the cases, and he admitted that some of those foreign asset protection trust failures didn't even involve a foreign asset protection trust. This list was highly misleading, and it cast a lot of doubt on a very legitimate industry. I believe the motive was to sell more domestic trust, but doing so under false pretenses is not a good thing for the industry. The public should know the truth. That's why me and my team dug deep into the case law, and ultimately we found that there's no supporting basis for this claim that there's been 45 failed foreign asset protection trust. You can read more about them at 45fact, fapt.com. Okay, so now it's the time that we will answer your questions. I've got about 20 minutes here to go through a few questions. So if you have some questions, feel free to drop your questions away, and I will start, and I will gladly address them. All right, so let's see. We've got our first question here. My main concerns around legalities. Is this strategy fully legal? Why is there so much skepticism around this space? Great question. And I would start with going to 45fapt.com. There have been attorneys who've been misrepresenting case law for a long time. Now, if you do something illegal and you have an offshore trust, yes, that could land you in jail. But as long as you comply with court orders, you don't lie to the court, you're not making late stage transfers, you're not going to end up in jail. And interestingly enough, the people who ended up in jail would have probably still gone to jail if they had a domestic trust. However, even despite going to jail, a lot of them were able to still keep their assets protected. So there's nothing illegal about setting up an offshore trust. When you work with my law firm or another reputable offshore asset protection law firm, you'll be able to avoid any jail and still keep the protection. All right, let's see what we got next. Bring them all on. Do those trusts make sense for non-US citizens with EU citizenship? They do. We do work with clients from Europe. I will say that lawsuits are more common and prevalent in the United States than in most of Europe. But depending on where you are, lawsuits may be prevalent as well. So yes, we're happy to help clients from other places outside the United States. So feel free to reach out and contact my firm, blakeharrislaw.com, or the phone number on the screen right there. We'll have an attorney schedule a call with you shortly. This is where you lost me. Once you start disparaging competitors, you lose all credibility. I've never disparaged anyone. I've told the truth about the industry, and the competitors who are lying may not like that. But I've never disparaged anyone. I'm just simply the truth teller, and I'm there to protect consumers of asset protection services from scammers like Kevin Wessel, and from attorneys like Steve Oceans who misrepresent case law, and from attorneys who lie about bridge trusts and claim they're offshore trust. There's nothing disparaging about bringing truth and transparency to the industry. Thank you. I talked to a guy named Oceans or something like that in Nevada, and he started saying the same about you, and I hung up on him. I guess slamming competitions is common in your industry. I have invited Oceans to go live, and I'm more than welcome to go live with Steve Oceans or any other attorney in this industry. I'm very curious about what his defense is, because so far, since I posted my response to his response on Monday, he's gone silent. We've got silent Steve right now. And I recommend you go to 45fapt.com and watch the video that I posted. Then watch the second video I posted, which includes his responses, where he said that he hasn't read the cases. And interestingly enough, even though he hasn't read the cases, and even though he hasn't, even though he's admitted that list contains cases which don't even involve a foreign trust, he still hasn't removed it from his marketing material. So yes, there are pirate ships in the industry, and I'm doing my best to spread light on what is going on in the asset protection industry and protect consumers of asset protection services. So thank you for your comment. My main concern is having my assets tied up by litigation. If a judgment is entered against me and I'm ordered to pay the opposing party, or my assets frozen until the judgment is satisfied? Good question. And the answer is no. You can still access your assets. Maybe it would be best if the trustee didn't send money directly to your bank account, but the trustee can still pay your mortgage. They can pay your credit card bill. They can send money to friends and family members. The money's still going to flow there for your benefit. It's just not going to go directly into a bucket, into a bank account, which a U.S. court can take from you. Thank you, Ryan. And how long can a court keep them restricted? Well, the court is not ever going to be able to restrict your foreign trustee. They can always send you money. They can continue to pull you in for debtor's exam every few months. They can continue to review your assets. They can continue to look at what you have. They can continue to make you request distributions, but a court is not going to be able to keep your assets from flowing through to your benefit. The trustee won't comply with any U.S. court order, and the trustee is going to still do their best to make sure the money is there for your benefit whenever possible. When we set up the Cook Islands Trust, are we the grantor and beneficiary? My understanding, we can only be grantor, beneficiary, trustee. We can't be more than one of these. Your understanding is actually incorrect. You can be more than one of those. You'd be the grantor and you'd be the beneficiary. The trustee would be a trust company out of the Cook Islands, probably Atlas Trust Company, the trust company I co-founded. But that's one of the beauties of the Cook Islands. They allow for the use of a self-settled asset protection trust, one where you can be both the grantor and the beneficiary and still get the benefits of a spendthrift provision, which means that it's a provision that protects the assets from being lost due to a lawsuit. So other questions we've got, what about banking? What are my options for banking? If you want to bank with your assets inside of a Cook Islands Trust, you have three main options. Option number one is the Cook Islands. Option number one, I'd say Switzerland and Liechtenstein. That's where the majority of our clients bank. Generally, the clients need about $1 million in order to be able to bank there. We do have certain situations where we can open up clients' accounts for as little as $500,000 in Switzerland. Next, we have the Cook Islands, which will open a bank account for as little as $250,000. Their fees are a little bit lower and can sometimes open accounts quicker than Switzerland. And then the third option is Panama. Next, how long does it cost? How long does it take to set up a trust, and how much does it cost? With our partnership with Atlas, we can get trust set up probably quicker than anyone else in the industry. In some cases, on average, we're setting up trust right now in about 2 weeks. And in some cases, we can get trust established in about half that time. In terms of pricing, we are very transparent with our pricing, probably the most in the industry. It's $25,000 at the time you hire our firm, and then there's an annual fee of $7,000. That annual $7,000 is a fully inclusive fee, which covers everything the trust company is going to do for you, everything my law firm is going to do for you, and everything the protector, the third-party protector, will do as well. There's no hourly billing from any of those companies going forward. There's no additional fees for opening up bank accounts, for distributions or gifts to the trust. There's no additional fees for government. There's no additional government fees either. All of that is fully inclusive. I don't know of anyone else in the industry who gives such clear, transparent, and inclusive flat fee pricings. There's others who may quote a cheaper upfront fee, but when you break it down and do all the add-ons, which they may not tell you about until you've engaged them, you may find out that you're ending up paying a lot more than the $7,000 a year we quote. How does Atlas compare to an established trust company like Southpack? Atlas is an established trust company. Atlas employs the best members of Southpack Trust. All of them have moved over. We have gotten nothing but excellent feedback from the clients who have worked with Atlas. Atlas also does a better job of using AI and technology than probably anybody else in the industry, and because of that, they're able to keep their fees low and their service high. Also, there's transparency in the ownership of Atlas, which I don't know if there's any other trust company that is as transparent about the owner. You want to know who your foreign trustee is? It's Atlas Trust Company. You want to know who the CEO is? It's Marcos Almeida. You want to know who owns Atlas Trust Company? It's both me and Marcos. I don't believe anybody else in the industry is that transparent. Also, it's all done on a flat fee basis, a $5,000 a year flat fee basis to serve as both the manager of your LLC and your Cook Islands Trust, and cover all the government fees and have no hourly billing whatsoever after that. You're not going to find a better value than what you find with Atlas Trust Company. What if I have a lawsuit pending? Can I set up a Cook Islands trust? In some cases, you still can. However, you're not going to get the same level of protection from that particular lawsuit that you would if you were to set up the trust well in advance of any litigation. You may be able to do some damage mitigation, but you definitely get a lot better protection if you do it before the lawsuit begins. Do you need a letter of recommendation when setting up the Cook Islands Trust? I believe that's no longer a requirement of the Cook Islands. They'll want to have a copy of your passport. If you have a passport, they'll also want a proof of your address, a utility bill or a deed or a lease would suffice. They'll also want to know how you made your money. If you're a 62-year-old doctor worth $1 million, they're not going to ask a whole lot of questions. But if you're 19 years old and worth $45 million, then they're going to want to know how you made your money, though it is becoming more common for people to have money at a younger age. The trust companies just want to make sure they're not dealing with anyone who made their money when in an inappropriate way. For the 25K, how many entities does that include? That includes the Cook Islands Trust and the Cook Islands LLC and the opening of the bank account, as well as all of our advice and guidance that go along into making that trust. Where do you see the offshore industry headed from a U.S. regulatory standpoint? From a regulatory standpoint, I don't see the U.S. government really caring that much about the offshore industry. There's a lot of talk about war or other hot topics. There's very little talk about increasing regulation in the offshore industry. My firm will monitor it closely, but the reality is a lot of the politicians or a lot of the people who fund politicians are the ones creating and using offshore trust, and they don't want this industry to disappear. What happens to the offshore trust when I die? When you die, your successor beneficiaries step in and they can serve as the beneficiary of the trust. They'll just need to supply your trustee with a death certificate. And then once the trustee has a death certificate, then they can step in and start distributing assets to the new beneficiary. What type of assets work well inside of a Cook Islands Trust? Well, most commonly, that would be liquid assets, stocks, bonds, cash. All of that can be held in a bank or brokerage account in Switzerland. The U.S. court has no way of touching it. The other most common asset is real estate. Real estate can be put directly into the trust, and it does make it harder for a third party to take away. However, because the asset still sits in the United States, there is a possibility that a foreign court that a U.S. court may still seize the asset, which is why it is wise to also engage in some type of equity stripping strategy where you put a mortgage or a lien on the property and to put the proceeds into an offshore account. Otherwise, pretty much any type of business can go into a Cook Islands Trust, aside from S corps, which generally stay out. But for businesses, you want to run them lean and mean. Pull out as much equity as you can and put that into an offshore trust as well. All right, we've got time for about one or two more questions today. I'm Blake Harris, managing attorney at Blake Harris Law, the nation's largest law firm exclusively focused on offshore asset protection. My firm, we set up more of these trusts probably than any other law firm in the world. We've never once lost a penny for a client. I've been to dozens of different countries and built up a network all over the world. Our team spans several continents. We've got members in several different countries. I'm the only U.S. attorney who is known to be licensed by the Cook Islands to own their own trust company. I encourage you to take some time and visit my website, blakeharrislaw.com. You can read some of our testimonials. You can read more about my background. I've spoken at events all across the United States. I've written several books on asset protection as well. Been quoted in Bloomberg, Forbes, Epic Times, ABC, NBC, CBS, Fox News. I've also been ranked by Martindale-Hubbell as their AV Premium rating, which is the highest peer rating for the legal ability, their highest peer rating for legal ability and ethical standards. If you have any other questions about asset protection. All right, looks like we've got one last question. We'll squeeze it out before we hit the 1:40 p.m. timer period. Have you spoken about FTC versus affordable media? Curious what your argument is here being held in contempt. FTC versus affordable media. Go to 45fact.com. It is covered there. This is the most cited case. And what's interesting is that while it is considered a failure of a foreign asset protection trust, the reality is quite different. So basically what happened was there's a telemarketing scheme and defendants were held in contempt after refusing to repatriate. They were the trust protectors with power to force repatriation. They pulled $1 million from the trust and tried to resign as protectors only after the FTC exposed their role. This is not a trust failure because a properly structured trust would never leave the seller holding protector powers that let them force repatriation. They retained too much control. This was a failure of drafting. This was poor drafting. This was not a failure of a foreign trust. Had they had a domestic trust, the result would have likely been the same. They would have still been held in contempt for having too much power and sitting in front of the court with that power, with that protector power position. But had they had a domestic trust, the court would have probably reached the assets. In this case, the plaintiff never actually broke into the trust. They attempted to litigate in the Cook Islands, but ultimately decided to settle with the Cook Islands Trust Company there. It's not actually a failure of a foreign trust, although domestic asset protection attorneys like to present it as such. That is not actually the reality. Okay, we got about 60 more seconds today. One final question. What other documents will you need from us when setting up the Cook Islands Trust? As I mentioned, a passport, if you have it, any proof of income would be helpful as well. List of family members, your ultimate beneficiaries after you pass away, and a proof of address. It's all very simple stuff. As a client of ours, we will walk you through and guide you on how to get everything put into place. Well, I hope you enjoyed today's webinar. Thank you very much for attending. We'll do another one of these perhaps about a week from now, where I think I'm going to dive deeper into the 45 foreign asset protection trust cases and dispel the myth that there's been 45 failed foreign asset protection trust. I think that's a very important topic. It's something that I want to bring and promote transparency in the industry about, because I know that misconception stops a lot of attorneys from getting into this line of work, which is unfortunate. It stops a lot of people from engaging in this type of work, and instead they end up setting up vulnerable, risky domestic asset protection trusts that give you very little settlement leverage. And don't let that happen to you. Don't let that happen to a friend. Set up an asset protection trust the right way, work with a reputable provider, and your money will stay safe and you will sleep well at night. Thank you very much for attending, and hope everyone enjoys the rest of their Wednesday.
If you're watching this, you built something worth protecting, and now you want peace of mind that it won't be taken away. I'm Blake Harris, managing attorney at Blake Harris Law, and I will explain how to get the best asset protection. There are two options in asset protection. Protect your assets here in America, where courts have pierced those structures repeatedly. The other option is creating an offshore trust in a jurisdiction such as here in the Cook Islands, where a U.S. court can't pierce your trust. Your Cook Islands trust will be paired with an offshore bank account in Switzerland or another reputable banking jurisdiction, which will help grow your wealth through diversified investment options. Two things you may have heard that aren't true: that a Cook Islands trust will land you in jail, and that the IRS reporting requirements are complex. Neither of those statements are factual. It's fully legal, and with proper guidance, it's very simple. Here's what no other attorney can say. Blake Harris Law is the nation's largest law firm focused exclusively on offshore asset protection planning. I'm also the only known U.S. attorney licensed by the Cook Islands government to own a trust company there, Atlas Trust Company. My law firm and Atlas charge flat fees for the entire engagement, never hourly. You'll know the full cost before you decide anything. And my law firm has likely established more Cook Islands Trust over the past few years than any other law firm in the world.